executive committee of a municipal council in general terms, which was the position in Democratic Party matter. The case is about fair representation within the context of a tie under Section 43 of the Constitution. It's not for general position. So Section 43 deals with a tie. And then the question is, what constitutes a fair manner to determine or to decide a tie in a situation where two or more political parties within the council have equality of the surpluses? That is the question to be determined. And we will link that with both Section 19 of the Constitution and Section 160, subsection 8 of the Constitution. So the first issue of the limitation of rights, we concede that that issue was not canvassed in the High Court. And I believe it's because the respondent did not participate in the High Court proceedings. But be it as it may, we submit that with reference to the judgment of this court in Makonyane, that is on paragraph 5 of our supplemented heads of arguments, where just to read particular part, it says, it is for the legislature or the party relying on the legislation to establish this justification and not for the party challenging it to show that it was not justified. So we submit that in the absence of a determination of Section 36(1) in the High Court, this court can still arrive at the conclusion that Section 43 of the Act is inconsistent with Sections 19(3) and 160, subsection 8 of the Constitution. So the issue of connection between Section 43 of the Act and Section 19(3) of the Constitution, we submit that the issue of elections is a continuous process. And in the following way, electorate go to the polls, and then they cast their votes, and then the votes give birth to the members of the council. How? Because in order to allocate seats within the council, there should be a counting of votes. And after counting the votes, there's a determination of who must sit in the council, and which is followed by election of the members of the executive committee. So we submit that votes give birth to council, and then council give birth to executive committee. So for that reason, we cannot separate the right to vote and the process under Section 43. So we submit that the right to vote is to express who must be in the council. And then after having expressed your view and through the vote as to who must be in the council, then the next step is who must be in the executive. So there is a link between the polls and the election of the members of the executive committee. And the distinction between this case and the case of Democratic Party. Before that, I want to make it clear that the applicant is in full agreement in terms of the judgment of Democratic Party the extent of defining the purpose of Section 160, subsection 8. Just to read a specific part of that judgment, it says, the object and purpose of Section 160, subsection 8A of the Constitution is to ensure, so far as is practically possible, that members representing political parties in a council participate fairly in the committees of the council. To that extent, we agree that position is correct. However, the distinction between this case and the Democratic Party case is that in the matter of Democratic Party, the issue of fair representation was strictly, or was on a general terms of who must be in the executive committee, on whether the issue of support of the electorate should be an issue where one political party got more seats in the council. And the slight difference is that the matter before this court, it deals with specifically where there is a tie, not on general terms. So we submit that the position in Democratic Party on the purpose of Section 1608, paragraph A of the Constitution, was correct to an extent that it does not deal with the issue of a tie under Section 43. So the circumstances in this matter are different because in this case, the issue is where two political parties are equal in terms of the seats and surpluses. What must happen? What must be a deciding factor? That is the question before this court, which was not the question before Luther J. in Democratic Party matter. So we submit that under the circumstances where two political parties or three political parties have achieved same number of seats and equality of the surpluses, there should be a deciding factor. And then the question is, what should be that deciding factor or that variable? So we submit that the variable should be going back to the issue of votes. Who got more votes? And if they are equal in terms of the votes, in terms of the seats, and in terms of the surpluses, therefore the issue of lot should be applicable. But in circumstances where there is a differentiation in terms of a factor which is the votes, we submit that a fair manner cannot be used in the lot. So, and we submit that to use a lot instead of considering an important factor or variable, which is the number of votes, will be inconsistent with the intention or the purpose of Section 19.3, because votes are used to give birth to the council, and then the council give birth to the executive committee. So on that basis, we submit that the use of lot renders the right to vote pointless. So on the issue of inconsistency with Section 160, subsection 8 of the Constitution, we maintain that reading Section 43 of the Act, this court must determine whether, in a case of equality of the surpluses, what is the appropriate or what is the most fair manner to decide the tie under Section 43, and we submit that if a lot is used instead of going back to the votes, we still submit that that is inconsistent with the purpose of Section 160, subsection A of the Constitution. So, and we submit that electoral support or the number of votes should serve as one of the factors or variables to decide a tie under Section 43 of the Constitution, so under 43 of the Act, to achieve fair representation within the context of a tie, with emphasis on within the context of a tie. So we emphasize that the number of votes should be used as one of the variables to decide a tie under Section 43 of the Act in order to achieve fair representation within the context of a tie. And the issue of remedy, I don't want to burden this court with submissions on this point. In our heads of arguments, the main heads of arguments, in particular paragraphs 53.1 to 53.4, we discussed what is our prayers or our proposal, if the court agrees with us on both issues or either of the issues. So, and just on remedies, the most important issue is we submit that the circumstances in this case do not warrant suspension of declaration of invalidity, because that suspension will result in suspension of democracy, given even the fact that in few months we'll be going for local government elections. And hence we propose the order in paragraph 53.1 to 53.4 of the main heads of arguments. And then the issue of course, if the court is with us, the respondent must be ordered to pay costs in this court and confirm the cost order in the High Court. Those are our submissions.
Thank you, Mr. De Vela. Just to deal with the facts, well, not the facts, the real substance of this matter. You want this court to confirm your client's position that because they got more votes, the lot system is unfair to them in terms of giving them seats in the executive committee. Is that the nub of your argument? Because yes, your client got more votes.
Yes, our position is that within the circumstances of the applicant in the municipality, so where it got more votes and there was a use of lot, the procedure or the use of lot, which is in terms of the act, is.
Do you agree with me that the legislature consciously prescribed the lot system to resolve situations where there's a tie? That's the legislature.
Yes, Section 43.
No. And the legislature thought that would be the fair manner of resolving the tie.
Yes.
So you want us to confirm what the High Court did, in a sense to say we as a judiciary are second-guessing, are saying what the legislature thinks is fair is not actually fair. Our view of fairness is to take account of the vote.
Yes, and doing that to be exercised in giving consideration to the right to vote in section 19 and the purpose of section 160 subsection 8 of the Constitution.
Yes, I think basically what I'm asking you is, and I think the Brakpan case says this, that we have to stay in our lane. The legislature or parliament has determined its rules of the game of how they'll resolve ties. What's our scope as a judiciary to say the way you've determined these rules is not fair?
We submit that the courts are not completely excluded from making that determination as to whether, in particular in this case, section 43, which deals with the issue of a tie, is consistent with the Constitution. So to that extent, to the extent of determining the inconsistency with the Constitution, we submit that the judiciary has those powers.
Thank you, Mr. Tabela.
Mr. Debela, you rely heavily on section 19.3. Now that section refers to elections to a legislative body. But an executive committee is not elected.
It's not elected.
No, it's established.
Yes.
So what does section 19.3 have to do with this executive committee? You see, a council is formed based on the number of votes cast. So proportionally, seats are allocated in that council, and that's where section 19.3 plays a role, it seems to me. But then, committees, they are internal arrangements of a council. Do you accept that? There's no link between a committee, be it an executive committee or a mayoral committee, whatever committee, of a council to the elections. Do you accept that?
In answering that question, Justice Majid, I'll make reference to section 151, subsection 2.
I'm sorry, I'm struggling to hear you. I know you don't have a loud voice like some of my colleagues, but
I'll specifically make reference to the provisions of section 151, subsection 2 of the Constitution, and I'll draw the link between the council and the executive. It says the executive and legislative authority of a municipality is vested in its municipal council. So we submit that the executive committee and the municipal council exist intertwined. The challenge is within the municipality, there is a thin line between the committees and the municipal council, as opposed to the national government, where there is a clear distinction between the executive and the legislature. So, in answering that question also, I think the court must also take into consideration the provisions of section, I think, I'll find that section, but
we can let one
very same section 160, subsection 8.
I've seen your written submissions. Can I ask you to go to the Act, please? Have you got the Act in front of you? Do you have the Act in front of you?
The,
The Municipal Structures Act, the one we're dealing with.
yes,
Section 22 deals with the election of councils, and it talks about proportional representation. I'm just mentioning that as a background to go to section 33, please. Establish criteria for establishment of committees. Do you have section 33?
section 33 of the Act.
Yes, sir.
Yes.
You are there.
Just my learned colleague is assisting me because he's in both Afrikaans and
Thank you, Mr. Mpofu.
yes. Thank you. Thank you. Yes.
Okay, now, first of all, again, it talks about establishment, not election, but that's just the caption.
Yes.
Now, it says a municipality may establish a committee. So not all municipalities have committees.
Yes. Yes.
They can only do so if they are empowered to, in terms of the Act, to have a committee, and we know that the Act prescribes that.
Yes.
So what I'm saying to you, this executive committee, it's got nothing to do with elections and with votes. It's internal arrangements of the council.
We submit that, and which submission I think we made previously to say votes give birth to the municipal council, and then municipal council is extended to executive committees. So in a situation where a municipality has executive committee or has committees, we submit that those committees are given birth by the votes which were cast during election. So the process is continuous. You vote for the members of the council, and then the members of the council give birth to executive committee. That is the link. What in our submission we're trying to establish a link between these votes and the establishment of executive committees only in municipalities where there is executive committees.
I was going to ask you not to give Mr. Mpofu's book back too quickly, because I'm going to section 42 now.
I'm there.
So do you see the heading chapter 4? It tells you what that next chapter is all about, under which section 42 and 43 and 44 falls. It's internal structures and functionaries. These internal arrangements. Then it says about executive committees, 42. Only municipalities of certain types may establish executive committees in sections 8A, B, C, and D. You see that?
Yes.
So I'm saying to you again, this has got nothing to do with votes and proportionality. And this is about seats. It's not about votes.
Okay. Assuming we remove elections from the picture, we submit that we will not have municipal council and we will not have executive
Purposes. You can't remove elections from this. We accept that the councils are elected proportionally. But when it comes to the internal arrangements, all that the statute requires is that there must be fair representation. So if they say there is an equality of surplus of votes, because you must read the whole section 43(2), A, B, and C. If A doesn't work, then you go to B.
Yes.
B doesn't work, you go to C. Now with C, the legislature says, where there's an equality of surplus, because remember now we're dealing with seats on that executive committee. You can't have a fractional seat. It must be one seat per person. One person, one seat. So you can't have fractional seats. So where there's an equality of surplus, they say you determine it by lot. It would have been different if this had to deal with a council, where votes matter, where proportionality matters. And then where a certain party like yours has more votes than the other, than the DA, it would have been different. But here, we're dealing with internal arrangements, it's establishment of committees, and therefore, the legislature has decided we will break the deadlock by way of a lot. Now, as the DCJ has asked you in the beginning, what is wrong with the lot system in that scenario where we're dealing with discretionary committees, internal arrangement committees? What is wrong with the lot system there?
I think the High Court dealt with that aspect to say, when you decide a tie under Section 43, you should not, as a manner of resolving this tie, you should not exclusively look at the issue of surpluses. You must also consider other variables. And where all these variables are the same, including the votes, then lot will be appropriate. So we submit that a lot is not completely to be excluded, but it should only be used as a last resort in a situation where all variables or all factors are the same.
I've heard you. Now, last question. I have the amendment in front of me. Now, we know that the legislature wouldn't just have amended this piece of legislation. There must be reason for it, must be calculated, they must have thought about it, and then it was passed. Before this amendment, the section read, if the council of a municipality established, that's 43(1)(a), sorry. If the council of a municipality establishes an executive committee, it must elect a number of councillors. That's the pre-amendment version. Now it reads, instead of elect, it must determine a number of councillors necessary. And then later it says, sorry, let me just get this, the Afrikaans is on the other page. Oh, subsection 3 was completely deleted, and the old subsection 3 dealt with representation that doesn't conflict with section 168. Why do you think they changed it from elected to determined and deleted subsection 3? Because those are significant changes for purposes of the debate we're having now. What would you say was the rationale behind changing it?
I may not have the rationale behind the change, but my submission is, following the change, the applicant is before this court to say, after the amendment, please test the validity of the provision of section 43 as it is now. So there may be reasons why the legislature decided to make that amendment. And those reasons, of course, they are not before the court today. But we submit that in the current form, Section 43 offends the provisions of Section 19.3 and 160 subsection H of the Constitution.
Goes on. Let me repeat. I think it's significant that the pre-amended version of the Act before 2021, Section 43.3 read thus: a municipal council may determine any alternative mechanism for the election of an executive committee, provided it complies with Section 160 sub 8 of the Constitution. That has now been deleted.
No, I can't think of any.
Thank you, Mr. Tebele, thank you. So, it seems to me that your complaint is one of unfairness, correct? I mean, you're saying
Yeah.
that the system wasn't fair, the lot system.
Yes.
Yes. So let me just take you through my understanding of this, and I want to get your understanding as well. So what happens here is a process that's in two phases, correct? Voters go and they cast their vote. Their votes are converted into seats or into councillors, correct?
Yes, that is correct.
In that process, every vote counts, correct?
Yes,
Not every vote will have an outcome, but every vote counts, correct?
of course, yes.
Right. Once that process is complete, you now have a council with seats, correct?
Yes,
So now you go into your second phase, where the seats are used to determine the executive committee, correct?
yes,
Once everybody is in council, would you accept that every vote carries an equal weight?
yes,
So if the DA and SADA both had 2 seats in council,
yes,
but SADA had 400 more votes,
yes,
when it comes to voting in council, when it comes to the weight to be given to those seats, they're identical, correct? For the purposes of council.
yes,
Yes. And so SADA could never say that we had 400 more votes, so therefore our 2 seats must count a bit more. That's not on,
that is not our case.
because the votes have been counted and they're in. Now the Act clearly says that you now use seats to determine the representation on the executive committee. Section 43(2)(a)
Yes,
speaks of seats being the basis of the formula,
yes,
correct? And that section has not been challenged, correct?
yes,
Even though the reference is to seats only and not to votes.
yes,
So when a determination is made in terms of calculating the surplus, it is correct that it is based on seats. You don't have a difficulty with that,
yes,
right?
and divide by the yes,
Exactly.
yes.
So,
Formula is correct, it's fine.
right, so in line with the questions my colleagues asked, one cannot then go back to the number of votes to determine a tie, because the formula is not based on the number of votes. The formula which you accept is based on the number of seats. And therefore, there is a tie,
Yes,
which can't be resolved through the number of votes, because the number of votes have already been properly taken into account in the calculation, and they carry equal weight in council. And that's why you have the tie.
yes, and extension of that process. We submit that when these two political parties have achieved equal seats in the council, and obviously that will amount to equality of the surpluses. Then our submission is that the votes should be a deciding factor, should not
Okay.
completely be excluded.
Okay. So you say that will be fair.
That would be a fair manner.
Let me get on to my second issue then. Because what is mathematically fair and what is politically fair may not be the same thing. And let me explain. So on the current calculations, SADA and DA would be entitled to a quarter person on the executive committee, not so,
Yes.
right?
Yes.
But they actually get 3/4 more. They get one, correct? Well, one of them get one person.
One in the
They get one person.
executive, yes.
But fairly, mathematically, they're only entitled to a quarter person, not so. I mean, that's the calculation,
That's the
0.259,
calculation, yes. That's
right?
mathematical,
Mathematically, yeah.
yes.
But you're saying it's not unfair for them to get a full person.
We are saying, why these two political parties, our case is,
Well, let me put it this way.
Why we
You're getting more than you earned, not so. In real terms, you're getting more than what you earned proportionately. You earned a quarter.
yes, but that is not the applicant's case. The applicant's case is not exclusively on the facts of what happened, but it deals with, a resolution of a tie in any other situation where it could be found that there is equality of the surpluses.
Yeah.
So our case is, in all fairness, if you have to determine which one seat must go, which political party must get the remaining seat in the executive, a fair manner would be to go back and consider the issue of
Okay. So you see, because
that would be in line with the democratic purpose and expression of the voters.
okay, you see, the difficulty I have is that you can't be selective about fairness. So I'm not very good at maths, but I did some calculations. So the ANC, for example, has 54 councillors, correct? And they get 7 members on the executive committee, which means that for every 7.7 councillors, they get 1 seat, right? The EFF, for every the ANC, sorry, for every 7.7 councillors. So they have to earn 7.7 councillors to get 1 seat. The EFF has to have 7 councillors to get 1 seat. SADA and the DA only need to get 2 councillors to get 1 seat.
Yes.
That's not fair, is it?
Okay. Our case is
No, I'm asking you whether that's fair.
they got equal seats in the council.
No, they're not got equal. You mean SADA and DA?
And yes, they got
Yeah, no, I'm
seats in the
talking about
council.
fairness generally. I'm trying to make the point that was made by Justice Klute in the Democratic, that fairness, and I want to just get the correct phrase you used, maybe. Yes, he said fairness is to be determined according to the representation on the council and not according to political support amongst the electorate.
Yes.
And that doesn't seem to be a problematic proposition, is it? Because the formula is based on political support in the council.
Yes.
Yeah.
But where we differ with we differ slightly with that position on the basis that what was the issue before Klute J is not the issue before this court.
Sure, but I think Klute J was expressing a general principle with regard to his concept of how fairness is to be determined.
Yes. So within in this court, the issue of fair representation is within the context of a tie. So we narrowed it down to resolving a tie, which is the difference between the two.
Okay. Maybe just lastly from my side, you rely quite heavily on the High Court judgment for confirmation, correct?
Yes.
But the High Court has consistently in its judgment, and I can give you those references, in paragraph 42, it makes reference to the work of Statler and Dispossessed and explains that the formula in section 43, where seats are awarded on the executive committee, establishes a system of proportionality in terms of which the composition of the executive committee mirrors the composition of the council. So the reference is to the composition of the council and the executive committee. And that same approach is adopted by the High Court in paragraph 43 and paragraph 45. So in line with my brother Justice Majid's propositions to you, at this point we're not dealing with the number of votes. We're dealing with the representation in council. Yeah. And that formula and that method of determining seats has never been challenged. And that leads to the problem that you say arises. Because that will always lead to a tie, not so. If you use the number of seats.
Yes.
It will always lead to a tie. And that's, if there is a problem, and I'm not saying it is, that's the source of the problem.
Yes.
But that's never been challenged.
Our case is, okay, there is, if you are equal in terms of the seats, obviously you are going to have equality in terms of the surpluses. Then the question is, what should be a deciding factor? Which is fair, which will achieve the purpose of the right to vote and the purpose of section 160 subsection 8.
And just lastly, Mr. Tibela,
paragraph 56 of the judgment of the High Court.
56, you say?
Yes, 56. It says, when a number of candidates or political parties vying for the same position or seat obtain the exact same number of valid votes, drawing lots seems the only fair and sensible way to finally determine representation. So we agree with that conclusion. Yeah. To say lots should only be used if there is the political parties are in the same position in terms of seats and number of votes. And then the court says the question that needs to be determined in CASU, however, is whether the allocation of a seat on the executive committee of a municipality, where there is an equality of the surpluses, but an inequality of votes obtained in the election, is consistent with sections 193 and 160 subsection 8 of the Constitution.
Yes, I hear that and I see the High Court's reasoning. The difficulty simply is that the High Court sought to invoke a criteria, which is the number of votes, which is not the criteria that the legislature has adopted, which is the number of seats. And the High Court doesn't deal with that at all. So just finally, it's also a major problem that there are 7 seats, all the small parties that got 1 vote each. They're not on council, correct? They're not on the executive committee. So what is politically fair is really always not a question that the court is best placed to determine. That's a political question, as the Deputy Chief Justice has put to you. And unless it is so blatantly or glaringly unfair, there's no basis for this court to really second guess that. And that's what the jurisprudence of this court has said. It's the models that are adopted is best left to Parliament. Yeah. Thank you.
Thank you, Justice Kolabe.
Mr. Tibela, I forgot to ask one thing, and if you may need Mr. Mpofu's book again, but can I just take you to section 30, 30. I'm sorry, I skipped one on my notes. And it says 30 sub 5.
Section 30.
30 subsection 5. 30 sub 5. It reads thus: before a municipal council takes a decision on any of the following matters, it must first require its executive committee or executive mayor, if it has such a committee or mayor, to submit to it a report and recommendation on the matter. Now, those are matters in terms of Section 160, sub 2 of the Constitution, and 100 sub 2 are important matters of passing of bylaws, approval of budgets, imposition of rates and taxes, and the raising of loans. That's the first one. And the second one that is an approval of, as we know it, an IDP, an Integrated Development Plan, and the appointment and conditions and service of the municipal manager. Do you accept these are the core functions of a municipal council? The council can only take those decisions if it has had a report and a recommendation from executive committee and executive mayor, if it has one. Do you accept that?
Yes.
So those executive committees and executive mayors, they don't have any powers to make any decisions on these matters in Section 160 sub 2 of the Constitution and the rest of the matters mentioned in Section 30 sub 5. You see that?
Yes, but the point is, okay, the point is not the importance of the executive committee. The point is these political parties which have a desire to be represented in the executive committee, how do they get into the committee? That is the question. Not necessarily the significance of the work of the executive committee.
Zatibila, isn't the simple point this? Doesn't matter how many people sit there of yours, of SADA, of the ANC or of the EFF. No matter how many of them sit there in the executive committee. The real power, constitutionally and legally, lies with the council. And there you are proportionally represented. Isn't that the real issue?
Okay, Section 160, subsection 8, is the section which gives birth to the issue of executive or the committees in the council. So we submit that in achieving the purpose of Section 160, subsection 8, it is necessary, even if it's not, it may look not to be significant to be represented in the executive, but the manner in which the members of political parties are elected into the executive committee in a situation of a tie should be in line with the very same constitution.
I think the criterion there is fairness in 160 sub 8, and Justice Colopin has dealt fully with fairness. Thank you, DC.
Which we submit within the context of a tie. Fairness would be to consider the votes.
Thank you.
Mr. Tibile, can you recall last time why this matter was adjourned?
I think among other issues was the findings in Brakpan case and how is different from this matter.
The findings in?
Brakpan matter. Yes.
And the presiding judge, the former acting Deputy Chief Justice, Matlanga, had asked the applicants or counsel for the applicant to explain why the lot system was unfair or constitutional. Do you recall that?
Yes.
And do you recall counsel's response to that?
So you are forgiven.
No.
If I recall correctly, counsel had said that they were not prepared on that aspect and wanted some time to consider that.
Yes.
Yes?
I remember that.
Are you able to address us today?
Okay, I think our submission is that you consider the number of votes.
Yes, the question that was posed, which I repeat, was what was wrong with the lot system?
It doesn't, it carries the consequences of putting two political parties or political interests with equal seats in the council. But
The lot system doesn't refer to votes.
it refers to surpluses.
But it doesn't refer specifically to the number of votes
Yes,
that was got.
I totally agree.
So the lot system is not directly, and I think this is what Justice Colopan and Justice Majid was also asking about, is not directly related to the votes, to the number of votes.
We submit that in consideration of whether there is a link between the lot system and the votes, our position is that there is votes which constituted council, and then which council go into the executive. Of course, on the strict interpretation, it seems like there is no link. But on,
So if there's no link, how does it then relate to section 19.3? There's no link between the composition of the committee and the number of actual votes directly.
okay, Justice Theron, my response was not that there is no link, was on a strict interpretation. It seems like there is no link, but our submission is that there is a link, and in my
We can't see the link in the legislation.
in section 19, subsection 3 of the Constitution, section 19.3, it says, every other citizen has the right to vote in elections for any legislative body established in terms of the Constitution, and to do so in secret, and to stand for public office, and if elected, to hold office. So we submit that this right to vote is exercised during elections. And then the objective of,
Sorry to interrupt you. So they can vote for a legislative body,
yes,
right?
yes,
And that would be the council.
the municipal council, yes.
Is the executive committee a legislative body? Or is it an internal committee working arrangement as Justice Majid had suggested to you?
In terms of,
And if you look at section 160, the heading to section 160 is internal procedures. So it's dealing there with the functioning, the internal workings of the municipal council. So the municipal council is the legislative body.
yes,
So citizens have a right to vote for any legislative body.
yes,
The municipal council is a legislative body.
the executive and legislative authority of that council, of a municipality, is vested in that council.
Sorry, the legislative?
The executive and legislative authority
Yes,
of a municipality
yes.
is vested in the the council.
in the municipal council.
Yes, in terms of,
Yes, and citizens have a right to vote for the council.
yes.
Yes.
And then which council give birth to the executive?
Is the executive committee a legislative body?
Is a product of a legislative body.
Is it a legislative body?
No. Is,
So then there's no link with section 19.3.
we
Because section 93 allows one to vote for a legislative body.
yes. And which we submit that the same legislative body being the council gives birth to the executive,
Gives back what to the executive?
gives birth to the executive committee.
Who gives what back to the executive committee?
I'm
I'm trying to understand your submission,
yes.
Mr. Tibili. When you say gives back to the executive committee, what do you mean?
I mean, in a municipality where there is a provision for executive committee,
Yes,
after the election of the council,
yes.
then the council elect the executive committee. Only in a municipality where there is a provision for executive committee.
Now, section 160, sub 8, deals with the composition of the committees, right?
Yes,
So members of a municipal council can participate in the committee in
Yes.
a manner that A, allows parties and interests reflected within the council to be fairly represented,
that's correct.
in a manner that's consistent with democracy, and it may be regulated by national legislation. Now, how does section 43(2)(c), how is that provision inconsistent with what I've read to you now from section 168?
Okay. Our submission is that in order to give effect to fair representation entrenched in section 160, subsection 8, in a situation where there is a tie, votes should be considered. In giving effect to the fair representation,
Please listen to my question. In what manner is section 43(2)(c) inconsistent with the requirements that are set out in section 160 sub 8?
okay,
So now the way you have to answer that question, you have to look at section 43(2) and how seats are awarded on the executive committee,
yes,
and whether what is proposed or what is in section 43(2), in what way it's inconsistent with 160 sub 8.
which our submission is the only part, the part which deals with the use of lot where there's an equality of the surpluses. That part is inconsistent with the objects of section 160, subsection 8.
Please refer me to that part that you're referring to.
In our, I think it's on paragraph 33 of our main heads. That is the part we underlined. Paragraph 33 of our main heads, it says, members of a municipal council are entitled to participate. Sorry, no, it's not. I'm reading section 160. I'm sorry.
Which part of section 43(2) of the Act is inconsistent.
C, which says if there is an equality of the surpluses, the result must be determined by law.
And what is the applicant's submission as to how we could make that section 43(2)(c) constitutionally compliant? How should it read to be constitutionally compliant?
Sections 43, 2, and C.
Yes.
Okay, let me start with subsection C, which says the award of seats on the executive committee to political parties or political interests must be determined in the following.
Yes.
And then the method or the formula. Yes, and then going down with the very same formula, it says if using this formula, then the result is that there is a tie. And then that must be resolved through lot.
Yes. What does the applicant say can be done to cure that? On the assumption that I'm with the applicant, I'm speaking for myself now. On the assumption that I'm with you, that section is unconstitutional, what would the applicant say? How should 43(2)(c) read
Yes.
to make it constitutionally compliant?
So we propose it should read as follows. If there is an equality of the surpluses, the result must be determined by the political party or political interest with the highest number of votes obtained during the elections.
Then it means then that the applicant's party would be able to put a quarter person on the committee.
Okay, it means
If we go according to the votes then.
if we, okay,
Would that be right?
the deciding factor, in fact, the deciding,
Let's take it step by step, Mr. Tibile.
yes.
If we go according to the votes, if we change 43(2)(c) to say we go according to the votes, then as Justice Colopin put to you, then if the party that got more votes, then the applicant would be entitled to have a quarter person on the executive committee. Would that be right?
No, oh, okay. Let me answer that question in
How would
specifically.
you put a quarter person on the executive committee?
Okay, let me answer that question in with reference to what happened. In this case, there was once.
Tibile, I want you to answer the question with reference to your suggestion here that we change 43(2)(c) to say the votes must be the governing factor.
Yes, I'm coming to that. I'll come to that.
Yes,
I'm saying in this case, what happened is that there was one seat remaining
yes,
in the executive, and then we had DA and SADA with equal seats
yes,
in the council.
Yes.
Then applying the formula, it resulted in equal surpluses. And then with a proposed reading of the section by the applicant, we submit that. And in that situation, the deciding factor as to who should get the seat should be which political party obtained the highest number of votes. That should be the deciding factor. Which political party obtained the highest number of votes between the two with equal surpluses?
So
if DA got 400 votes and SADA got 402 votes, so with the proposed reading of the section, therefore, the deciding factor will be the highest number of votes to resolve this tie.
if the lot had gone in favor of the applicant, would the applicant be in court today?
Yes,
Why?
because the applicant's view is that to use that lot is not,
If the lot had gone in favor of the applicant, if the applicant
Yes, of
had been
course.
given this extra three-quarter person and said, now you can have one full person on,
I can assure you,
would the applicant have been in court?
yes, but not with not, but the facts will be this, will be different.
If the applicant would still then have been in court, what would the applicant have been asking for?
To say the use of lot, okay, let me, if DA had highest number of votes than the applicant, then the applicant can still come to court.
No. If on the facts that we have before us,
It's different, yes.
on the facts that we had before us,
Yes,
the lot had gone in favor of the applicant, would the applicant have come to court?
no.
So the applicant is really unhappy that the lot went against it. If the lot had gone in its favor, it would not have come to court.
Okay. Yes, it doesn't change the unconstitutionality of the section. It won't change the unconstitutionality of the section. That position being in favor of the applicant, unfortunately, doesn't change the alleged unconstitutionality.
Now, let's just take ourselves away from this case for a minute and look at how government functions. The cabinet. Who chooses the cabinet? Who chooses members of the cabinet?
The president.
But now, what about people who vote? Can't they say our votes must be taken into account somehow in the decision as to cabinet members?
Yes, hence I made a distinction at the beginning of my submissions. At some point I said, it's different from the national government. Within a municipality, the position is different in that there is a formula which is used to calculate, to determine who must be in the executive council. It's not one person. It's a formula in section 43 of the Act. That power is not vested in one person. It's in terms of section 43, which the applicant is challenging. We say to an extent that it does not consider one variable being votes is inconsistent with sections 19(3) and 160 subsection A.
Now, my brother Justice Majid referred you to the old Act and the differences between section 43 in the previous version of the Act and the current version. In your own words, what would you say is the difference between the two versions?
Is the introduction of the formula in the current section 43, the formula to determine allocation of seats in the.
Would you agree that in the previous version, a wide discretion was given to municipal council members regarding the composition of the executive committee, with the proviso that representation in the executive committee must be, and I quote, substantially in the same proportion as representation in the council? Do you agree with that?
Yeah, I get that.
Do you agree with that?
So,
That was the formulation in the previous version of the Act.
yes, I thought
So there was a wide discretion,
on the council.
yes.
Yeah.
As long as representation is substantially in the same proportion
Within the,
as representation in council.
yes,
So even the previous Act didn't say it must be exactly the same.
yes,
You recognize that?
yes,
And would you agree that the current act is far more prescriptive. The current act prescribes the manner in which the deadlock must be broken.
Yes. Which the applicant is.
Now,
taking
what do we make of that? That in the old act, the committee and the members had a wide discretion. This discretion has been narrowed down in the new act. What does that tell us about the legislative intent and purpose?
Okay. I think in the current section 43, that the formula, the purpose of the formula was strictly to deal with a situation where a determination has to be made as to which seat in the executive must be given to a certain political party where there is the equality of the surplus.
Yes, I'm asking you a broader question. Asking you a broader question about legislative purpose and intent between the old act and the new act, and particularly this section. What can we glean from the changes in the legislation?
Was to specifically resolve a task.
Yes. Now, the legislature sat and decided that this is how it should work.
Yes.
Why should a court change that? Because then the court would be legislating, isn't that so?
The court, okay, what this court is tasked to do today is not to overpower the legislature, is to look into the provisions of section 43 of the Act and make a determination with the facts and submissions made on whether this section is consistent with the two provisions of the Constitution. That is the only
Yes, but you see,
issue.
and once again, Mr. Tibiel, I'm speaking for myself. I haven't heard the applicant say why those two sections, or why section 160 sub 8, or why section 43 2C is inconsistent with 160 sub 8. I haven't heard the applicant say why. The applicant just says because it should be determined by the number of votes. The applicant is not pointing to unfairness, to discrimination. That's why I'm trying to understand why the applicant is saying that section 43(2)(c) is unconstitutional, or how it's contrary to what is 160 sub 8.
Justice Taran, we made a point to say, in terms of section 19.3, when people go to vote, they express their interest in who should be in
A legislative body,
Yes.
yes.
And then our submission is that that expression as to who must be in the legislative body is done in terms of the votes, and then the calculation or the allocation of the seats is made in accordance with that expression. And then I think that is not an issue. The allocation of seats within the council is made in accordance with that expression. And then we say, under that legislative body, we have executive committee. And then if we have executive committee and there is representation in the executive committee, and a situation arises where two political Okay. Section 19.3 should be read with section 1512, which says the executive and the legislative authority of a municipality is vested in the municipal council. That is the link between the executive and the council.
Mr. Tabela, I presume you are familiar with the provisions of Schedules 1 and 2 of the Structures Act, which contain the very formula that I think you would like this court to adopt. When it comes to the allocation of seats on legislative bodies, there are 7 provisions which have, you haven't put it quite this way, but which have the formula that you are saying is the only fair one. I just start with the first one, item 13.2 in the first schedule. It talks about calculating surpluses, and then it says, if the surplus for 2 or more parties is equal, the seat must be awarded to the party that obtained the highest number of valid votes. And there are 7 of these provisions in the schedules. So when it comes to the allocation of seats to the legislative bodies, the lawmaker used the very formula you have in mind. You say if there are equal surpluses, it should go to the party that obtained the highest number of votes.
That is our submission.
Yes. So the lawmaker had that very formulation in mind, and it used it in relation to the legislative bodies, but didn't use it in relation to executive committees, section 43(1)(c). It instead said by lots.
Yes.
Now let's consider the following. Although section 43 seems to be framed as if it's concerned with the composition of an executive committee only once, perhaps at the beginning of a legislative or an election cycle, I assume that if there are changes in the seats held by the political parties in that municipality, there may have to be a reconstitution of the executive committee. Say as a result of a by-election, SADA took off a seat from the ANC or the EFF and had 3 seats, and the DA still only had 2. I think the result of the formula, even before you came to lots, would be that
Different.
your client would then be entitled to a seat,
Yes.
and the DA would not on the EXCO.
Yeah.
But when we are talking about changes in voter support that are less than bring about a change in the number of seats held by a party, what does one do? Say there are several by-elections in a municipality, or in this particular municipality, and in those 2 or 3 ward elections, the DA now gets more votes than SADA previously got in those wards, as it were to wipe out the difference that existed, 300 or whatever overall. But not enough to win a seat. There's just some change in voter support. Would your view then require one to look at the voting numbers in the by-elections and say, well, if that party has now got more votes, it must now get the seat?
Yes, if subsequent to the by-elections, there was a need to elect a member of the executive.
The problem is one doesn't know what the voter support would be throughout. Say you had won this lot, 2 seats each, the DA and SADA, and you had won the lot and had the seat on the EXCO.
Yes.
The DA then picks up significant voter support in 2 ward elections and says, okay, well, we've now wiped out that difference that existed between us. We now want the seat. And you say, oh, but we don't know what's true. The DA's done well in those 2 wards, but SADA's very strong in several other wards. The only way you'd know what the true state of voter support in actual numbers is by having an election in the whole municipality. So mightn't one of the reasons be for the lawmaker having chosen a more rough and ready approach in section 43 to recognize that small parties who are only going to get a seat by equal surpluses, their voter support during the life of a municipality may change. At some stage, one party may have more voter support than another, but neither of them have enough swing to get an additional seat. Let's just have that exco seat chosen by lot. What would be, the problem doesn't arise at national or provincial level because it's a winner-take-all system when it comes to national and provincial cabinets. But you wanting a very precise proportional representation system on the exco, and that can only be done if one can accurately gauge what is the voter support at each stage during the life cycle of the council. Can one really do that?
Okay. We are saying, let's take an example with the by-elections. Let's take example with by-elections. If after the by-elections, DA got 2 seats and SADA got 2 seats, and there is a need to determine which one must be represented in the executive, if there is a seat in the executive, and DA got more votes in the by-elections, then we submit that within that tie, then DA should get the seat, in that the number of votes should be a deciding factor.
Even though at that stage one only knows what the swing in voter support has been in those particular wards, because you haven't had an election throughout the municipality.
Yes, but the votes within that ward, because there will be
Votes on which you rely in this case are not votes for specific wards. They include all your ward votes and all your list votes.
yes, because of the nature of the matter.
Yes.
Yes.
But as a result of by-elections, one may start seeing swings in particular wards, but one won't know what's going on elsewhere. So gauging exact voter number support for small political, or any political party, but for present purposes, the 2 small parties, may not be possible. So a system of drawing by lots recognizes that during the life cycle of the municipality, there may be changes in voter support partially reflected in by-elections, which are not significant enough to disturb the number of seats which political parties have, and that one should disregard that change in voter numbers and simply determine that particular exco seat by lot. All I'm doing is looking for a reason, because it's clear that the formulation you want us to accept was in front of the lawmaker. It had it, and it used it where it thought it appropriate. It didn't think it appropriate for exco. One of the exco possibilities may simply be that it appreciated that this was not a legislative body and one just wanted a more rough and ready approach if one got down to equal surpluses. But what I'm suggesting to you is that there may be a practical reason arising from by-elections and change in voter support that may make it sensible just to recognize that over 5 years, one of the smaller parties may go up and down in relation to its rival small party, but let's just have the seat allocated by lot. Because we're talking here about, say, 345 vote difference or whatever, but in another example, we need to apply this act in what if the surplus is 10? And there's a by-election and the DA gets 15 votes off SADA. And then suddenly the DA says, okay, well, we've now got 15, we've made up the deficit of 10, we've now got 15. And SADA says, yeah, but we're very strong in the other wards, which haven't yet had by-elections. What does one do?
Our submission is simply that if there is a change in terms of the composition of, or a need to add more member in the executive, then the proposed amendment should also be implemented under those circumstances.
Thank you.
That seems to be all the questions the court has for you. We will now take a 20-minute adjournment.
what we were saying, that on the sections, points in limine or preliminary points. Strictly speaking, they may not be that, but what we really meant when we call them points in limine is to indicate that those 2 points would be are fatal and dispositive of the rest of the case. That is the disconnection and or lack of connection and separation of powers. But we also just wanted to repeat the apology to the court for the late submission, even though it's not opposed. It was mainly due to administrative issues. And as a result, our heads of argument were put together under some kind of pressure. So if I may, could I just, there are some, what my former secretary used to call howlers of spelling errors and things like that. I just wanted to correct 1 or 2 of them from on our heads. So in paragraph 4, it says, it's supposed to say the leave of the court, not the leave of the court. And then where it says condemnation, it's supposed to say condonation. And then at paragraph 28, it's just the spelling of JAFTA, J, it's J-A-F-T-A. And the one that could have been dangerous is paragraph 45. It's supposed to say it has not been fully satisfactorily explained, but it says it has been. Then the last one at paragraph 54, we say that insofar as this honorable court is being called upon to choose in the straight fight, F, not sight, between Klute J and Van der Schyff J. Thank you. Now, to come to the topics themselves, the matter really resolves itself around the 2 issues that we have termed as preliminary or points in limine. Let's start with what we call the absence of the connection or the link. Now, it should be self-evident that these being confirmation proceedings, the issue really is the confirmation or non-confirmation of the finding of the unconstitutionality of Section 43(2)(c) on its terms, or on the terms of the judgment. In other words, there are only 2 reasons why 43(2)(c) is said to be unconstitutional. It is that it is in breach of Section 19(3) of the Constitution and also Section 160 bracket A of the Constitution. If we can demonstrate, as we intend to, that those two sections have nothing to do with Section 43(2)(c), a point that many of the issues raised by the justices really try to direct my learned friend to, then that's the end of it. Because it may well be unconstitutional for various reasons, but if it's not unconstitutional for the reasons that were determined by the High Court in relation to those two sections, then, well, then that's the end. Similarly, I'm now touching on the second point of. Let me develop the first point and deal with it and get it out of the way. Let's start with Section 19(3)(a). As it has been demonstrated, that section has got absolutely nothing to do with what we are busy with now. Section 19(3)(a), for various reasons, is not related, or as we put it in our heads, not directly related to the issue of the composition of the Executive Council at all. And there are many reasons, some of which we have pleaded. There's even a new one which came from Justice Machit's question about the difference between the establishment and the election and so on. Because Section 19(3)(a) also uses the word established in a different context. So let's look at the section 19(3)(a). The very opening words show the disconnect. Here, the SADA is seeking to assert, presumably, the rights of political parties for representation in the Executive Committee. But Section 19(3) is about the rights of adult citizens. So, right from the start, and we've distinguished this issue from locus standi. In terms of locus standi, SADA obviously has locus standi. That's a different matter. The issue is that they are not the beneficiaries of that particular right, or the intended beneficiaries of that right. Remember, there are three categories of right holders, so to speak. Most of the sections in the Constitution will say everyone. Everyone has the right to dignity and so on. So let's call that category 1. Category 2, there are rights that are imbued on citizens, such as the political rights and so on, or the right to vote to citizens. This one is even category 3, because it even qualifies citizens. It's adult, every adult citizen. So it's a very narrow focus. So you can't rely on that right for the current purposes, for that reason alone. Then, if you read on, you have a right to fair and regular elections for any legislative body established in terms of the Constitution. Let's break that down into two pieces as well. Free, fair, and regular elections. So that's what the subject of this section is. And we have made the point in our heads that that deals with the elections themselves, a point that was made, I think, by Justice Machito, Justice Cooperative, that it's a different phase of the process. My learned friend is, of course, correct in saying that his favorite expression is that this gives birth to this and gives birth. But we say, well, the fact that it gives birth doesn't mean, So this, what we're dealing with now, is the grandfather or the grandchild of that one. So I was joking to my learned friend, saying, well, on this logic, then, if my grandfather commits a crime, or if I commit a crime, they can imprison him, or because he gave birth to the person who gave birth to me. So, as lawyers, on a more serious note, we know that there is something called, for example, legal causation. So the mere fact that it's a sine qua non doesn't mean that it is legally connected. Of course, you wouldn't have a council if you never had elections in the first place, but that's irrelevant for current purposes. But there's a more subtle reason, constitutionally speaking, why the issue of free and fair elections specifically refers to the elections, literally, the elections that have a particular date that get carried on, not this kind of thing we're dealing with here. If you go to the to section 1D, the values of the Constitution. 1D says universal adult suffrage, a national common voters' roll, regular elections, and a multi-party system of democratic government to ensure accountability, responsiveness, and openness. So that's a list of various values in the Constitution. And those are not just a tautologous repetition of the same thing. So universal adult suffrage is one thing. Regular elections is another thing. A multi-party system of democratic government is also another thing. But they're all our values. So section 19 deals with regular elections. This case deals with multi-party system of democratic government. So that's another disconnect, a complete disconnect. And if the reference to that, if you look at sub 19.2, it talks about every citizen has the right to free, fair, and regular elections for any legislative body established in terms of the Constitution. So there can be no debate as to the fact that in section 19 we're dealing with regular elections and not this other issue here. The last is the one that has been made by the justices, that after we're dealing here with an executive body, and section 19.3a is about participation in legislative votes for a legislative body. And it is no answer. My learned friend, every time that question is posed, refers the court to section 151.2, which says that both the legislative and executive authority of the council resides in the council, in the municipal council. But that's a point against him, because that section actually shows that legislative function, authority, and the executive authority are two different things. The fact that they both ultimately reside in the council doesn't make them synonymous. And if they were synonymous, then we wouldn't use those adjectives. And if they were synonymous, as my learned friend tries to portray, then section 19.3 would have said again, people will vote, one of the justices make this point. People will vote, have a right to vote for legislative and executive bodies. So whichever way you look at it, Section 19.3a has got absolutely nothing to do with what we are busy with today. And therefore, the Section 43C of the Act can never be unconstitutional for breach of something that is completely unrelated. Then we move to Section 168. And 168 also has nothing to do with this case, for the reasons that have been also articulated to my learned friend. As Justice Majid pointed out, the entire chapter where Section 43 is found is about the internal arrangements and that kind of thing. And in the cases, it says that it's a composition, it's about the composition of the council, or rather, I'm sorry, of the executive. And composition and the manner of participation. 168 is about the manner of participation, internal procedural issues. That's a different thing completely from the composition of a particular body. So it's like a court or a board of directors or whatever. How it's composed is one thing. How it then operates, how it's its own internal arrangements, the quorum, this and the other, those are the internal arrangements. And that's what Section 168 deals with. Now, and that's the point, that's why I was saying that point is related to the Brakpan case. That's the case that is, the point that is made explicitly clear by Clute J in Brakpan, that it is not the electoral support that determines the representation in the Executive Council. So if this court were to find it in favor of my learned friend or in favor of SADA, or confirm the judgment of Van der Schyff J, that would mean this court will have to overturn or find that Brakpan was wrong. Because Brakpan is very clear that you do not, it uses it in so many words. It is not the electoral support. And their case and the judgment of Honorable Van der Schyff J is that it is. So it's a complete diametrically opposed view. It can be both. But in our respectful submission, Brakpan was correct on that point. Of course, my learned friend is correct. On the facts, it's distinguishable. It happened a long time ago during the days of flock crossing and all that. And it was a different set of facts in the sense that it was not dealing with a tie. But that's not the issue. The issue is that the principle is the same as to whether, as a criterion, you use electoral support or not. So that, with the greatest respect, would be the end of the case. If Section 43.2c has got nothing to do with Section 19.3a or Section 168 of the Constitution, then that's the end of it. But in case we are wrong on all of that, then we come to the point of separation of powers, which is also fatal, completely, totally fatal to the case of SADA. Now, let's say for some reason my learned friend is correct that I think it was Justice Colopen who made this point, that it would be fairer sometimes just forget about the legalese, you just have a feeling that it would be fairer if you were to take into account the number of votes. But so what? Then my learned friend is in the wrong place, because that he should go and address it in Cape Town to the legislature. He can go there, and SADA can go there or make representations there and make a strong case that it would be fairer if the number of votes were taken into account. It would be more democratic, quote unquote, and so on. And who knows, the legislature might be impressed by those arguments and take them to board, take them on board. But you can't come and say that to the judiciary. What is the judiciary going to do? The Act is very clear that even Section 168 that they rely on says that all these things are regulated by national legislation. And national legislation, or the legislature has done it, and that's it. There's nothing this court or any other court can do about it. Except, of course, if they could show that it was irrational and all the other usual qualifications. But there's not been no argument of rationality made to this court at all. We're just told that it's wrong or it would be better, but there's nothing a court can do about that. So on those two legs alone, or on each one of them, the case that really should be the end of the case. But let me just take on board some of the issues that were raised with my learned friend from the bench, which demonstrate that this case is really was wrongly decided, to put it crudely. Justice Rogers points out the fact that the formula favored by my learned friend or by SADA actually is applied elsewhere in the Constitution, or rather in the Act. In other words, there are parts of the Act where exactly what my learned friend is asking for happens, where they start by looking at the number of votes before they go to the drawing of the lots. But that's because those sections deal with the legislative bodies, not the kind of thing we're dealing with here. And it is clear from my learned friend's address that, and the judgment for that matter, that nobody is saying the lot, the system of the drawing of the lots is inherently unfair. They are simply saying, no, you must first do the number of votes, then you can come to the lot. Well, I'm glad they do that, because that is if you look at the historical development of the system of the lot, by the way, just means it's lottery, literally. It's the lotto. It's just a game of chance. That's all it means. And that's a system that has been used for centuries. Many centuries ago, it was even believed that it was a godly act. In other words, you'd put these lots, and whatever the Lord wanted to happen will happen. And therefore, that's the rationale it used to be given. But the reality is that it's just a game of chance. And that's what is done when the situation is the same. It's actually a fair system in that sense. It's used every day in football. Before they decide which side is going to play from which side, they spin a coin, or in cricket and so on. And nobody complains because they know it's fair. It's 50-50, as it were. So it's fair in that narrow sense. But the issue about its employment here goes to the point made by Justice Machit or Justice Kolopen about the three-quarter person. The reality of this entire system is meant is to resolve the fact that you cannot have a quarter person or a half person. And therefore, you have to find a way of rounding off the numbers. And the point that was made by Justice Rogers, you'll find it in the judgment, ironically. I think it's paragraph 32. Yes, 32 and 33 and 34. The judge there, Justice van der Schyff, makes those examples that were made by Justice Rogers. And on 2 occasions, she says, that's relevant to note that where scenario of excessive seats arises, a new quota of votes must be determined in accordance with the formula in 16.3. And here's the part, she says, fractions are again to be disregarded. And then again in paragraph 33, she also said, Schedule 2, fractions are to be disregarded. In other words, even in the allocation of seats to the council, fractions are disregarded. And in the language, if you were to believe my learned friend's theory, it means votes are wasted, or some people's votes are disregarded, and therefore that would be in breach of section 19.3a. But it's not, because you can't have, the reason why fractions are disregarded is not because those voters who constituted that fraction were unimportant. It's because you can't split a person and say, okay, you've just won half a seat, therefore you must cut someone and put them there. That's the only reason. And it's the same reason here. Because think of it like this. Once you are in the executive, you are in. You are equal. So that's, my learned friend looks for equality. That's the equality. We don't say, let's say the executive council has 10 people. 5 come from the ANC and 5 come from SADA. We don't then say there, if there's a tie and there's 5-5, they have to appoint the municipal manager. You don't say no, the 5 of the ANC must be more because they have more electoral support. The 5 from SADA, we don't worry about what they have to say because they have less political support. No. Once it's the people are there, then they are of equal vote. And actually, ironically, that system favors small parties like SADA or minority parties because otherwise then they would have junior members of the executive, as it were. So that system can never assist. Yes, I'm fine. Thanks.
Yeah. Any questions?
Mr. Mpofu, just a question on costs. I understand you came here to assist the court at our request, and we're very grateful for that. But in a sense, you stand in the shoes of the minister, minister's representative, who should have been here anyway.
Yes, and the,
But it's not your problem. In fact, we're grateful. But what about costs in this matter? Clearly, they had to come to court for confirmation, and it seems to me that they deserve some by-watch protection. What do you say?
yes. Well, the only by-watch protection they deserve and should get is that the no cost order should be made against them, even if they lose. So that's it. But the order that was granted, which says that the minister must pay the costs, there's no basis for that.
I speak under correction, but I think there's a judgment, maybe even more than one of this court, that says the minister should bear the costs where it concerns a matter of this nature, concerning, well, definitely for the enforcement of constitutional rights.
Yes.
But what about confirmations of invalidity?
It cannot apply. Yes, there is that law. Well, firstly, there are two answers to that. The first one is that, of course, if the minister is opposed, then they can bear the cost. The second answer is that in fact, it's an answer against me. There is also authority for the proposition, Justice Machit, that the government is not like any other litigant. So they can't just say, well, whatever happens must happen. They almost have a duty to assist the court. Yeah. So that could have been the only basis, really, for awarding costs.
You see, what concerns me, Mr. Mpofu, here you are with your junior, and we are much indebted to you.
That's good.
Now, the High Court had the same problem. The minister just didn't pitch. Then she sought to have, I think, Madam Justice van der Schuyf sought to have amici come and argue. They didn't argue. And on the face of it, the outcome may well be that this invalid declaration is not confirmed. Now, that has vast implications for the legislature, but also for the administration of justice. Our minister could just not come. But the other question may well be a question of punitive costs against the minister personally and so on, but that's got nothing to do with you, so I won't ask you that.
I must say, Justice Machit, there is no excuse for the kind of laissez-faire attitude that the minister took. As you correctly, this is a very serious matter. Imagine if this is confirmed, the implications it will have just in the elections that are coming next year. In these days where, there are no longer clear majorities, let me put it that way.
Very fluid.
Yes, in these days of the fluidity, everyone would be watching this with hawk eyes, obviously, and there'll be so many, even the courts would be clogged with unnecessary fights about who should be in the executive. So it's not a matter where one can just shrug it off.
Mr. Mpofu, wouldn't prejudice be suffered by a party with more votes than another party, and they excluded from the executive committee? Because then they would not be able to participate in high-level programming development.
Sorry, I just missed the first part. Wouldn't
Wouldn't the
Yes.
party in that position suffer prejudice?
No, certainly.
Were they excluded from
Participation.
yes.
No, fair enough, Justice Taron. Yes. No, there's no doubt about it. But as we know from the Haxon case and all those, mere differentiation doesn't mean unfair discrimination. Or even, let me put it this way, mere discrimination doesn't make it unfair discrimination. So, yes, of course, there is prejudice at that level. And there is even unfairness or undemocratic, all the things my learned friend was saying. But the point is that that is constitutionally allowed. That's really the point. So just as I was making this example to my learned friend, and this, I can say this from the bar, that, for example, the ANC in the last election got 40%, 40 point something, but they have 159 seats in Cape Town. 40% of 400 should be 160, but because the system allows that, it can't come here and say, no, we want our extra seat because we got 40%, because it's constitutionally permitted. That unfairness, quote unquote, is constitutionally permitted. And once unfairness is constitutionally permitted, that's the end of it.
Thank you, Mr. Thank you.
Thank you very much, Advocate Mpofu. I think I want to, no, there's no other question. Oh,
Just ask-
another one.
Can I just ask one question arising to some extent out of that? Mr. Mpofu, you dealt with the disconnect between 19.3 and 42. Now, it does seem that 19.3 is the entry point for voters, that you vote in legislative elections. Whether that should be the entry point and the end point is debatable, because our system of democracy has both elements of participation and elements of representativity.
Absolutely,
So you participate, and then you are represented.
yes.
And so the argument that there's only reference to legislative bodies perhaps is understandable, because after you participate, then your representatives represent you.
Absolutely,
And those representatives may represent you in different structures, including an executive committee. So the argument may well be that even though the section doesn't speak to executive bodies, it shouldn't, because you don't vote for them.
yes.
But they are a natural continuation of what you do under 19.3, and therefore there's a golden thread that runs through them. And therefore, it's important that the proper weight and value of your vote is retained throughout the process.
Yes.
And if it's diminished, or if less weight is attached to it, that offends the constitutional scheme. And therefore, we must interpret 42 in that way, so that, in a sense, one doesn't do it mechanically, but one doesn't lose sight of the value and the weight of the vote.
Yeah.
What would you say to a proposition like that?
Well, the two answers. One is, of course, my learned friend's thing of the parentage is correct, but it undermines the fact that we're talking about different stages of the democratic process, so to speak. But the second answer lies in the fact that our system is inherently, especially in this context, let me put it this way, it permits proportional representation. And actually, that's the third reason. So I'm just diverting a bit, Justice Coloper. When I say there's the disconnect between 160A, 8, and 42(3)C, the real section that deals, that my learned friend should be relying on is 157. That's the section that there's a direct connect. If you look at the heading of 157, it says composition. So that's what we're busy with here. Not the one of the internal arrangement. But the third reason, Justice Colopen, is what was said, I think, by I think it's Clute no, it's Van der Schyff, J, in this very judgment, at paragraph 48, when she's dealing with the Clute J judgment. She makes the point, which is correct, by the way, that those cases confirms that in a system based on proportional representation, the majority vote is not the be-all and end-all determining the composition of the executive committee for municipal council. That's the point. The system, if we had a system which makes the majority vote to the be-all and end-all, then we could have these debates. So on whichever way you look at it. And by the way, just to not to belabor the point, if the SADA formulation were to be adopted, then they should say the entire section is unconstitutional. Because remember, you would never get to this situation of the lot if all you were looking for was the electoral support. There would never be a tie, as it were, unless if you got equal votes. The mere fact that we even have this, so they should be saying then the whole section must be taken away, because in which scenario would you ever have to draw the lot? Because all you needed to do is just to simply look who got the highest votes, boom, you are in the executive.
Thank you, Advocate Mpofu. I just want to echo Justice Majid's thanks to yourself and to the Pan-African Bar Association for responding to our request for assistance in this matter.
Thank
you very much.
Justice. My learned friend and I will convey them.
Thank you very much.
Thank
you. Advocate Devila, do you have a reply?
Deputy Chief Justice, I don't think there is any submission which is foreign from my learned colleagues' submissions, which I think I have to deal with, so I will not have any reply.
Just speak louder, I can't hear you.
I'm saying I don't think on the submissions made by my learned colleague there is anything foreign which I didn't deal with during my submissions.
I see.
So,
So you don't have a reply?
Yes, no reply.
Okay. Advocate Devila, I want to thank you for bringing a large contingent of counsel to support you to experience proceedings in this court. That's commendable.
Thank you.
And then in future, when you appear here, when you have an engagement with a justice on the bench, be sure to engage and direct your responses to that justice in name, like you had a debate with myself, Justice Kolapen, Justice Majid, Justice Thron, Justice Rogers. You acknowledge and say Justice Rogers, so Justice Majid, this is how it's done in this court.
Thank you, DCJ.
Thank you. Thank you very much. Judgment in this matter is reserved. Court adjourns.